Thanks everybody for attending Bytes of Innovation. My name is Martin Willemink. I'm one of the co-founders at SegMed, and I'm very happy to introduce our new speaker for this Bytes of Innovation webinar. First, a little bit of background about Bytes of Innovation. So Bytes of Innovation provides a deep dive into the future of medicine. And we do this with renowned experts such as researchers, physicians, investors, and lawyers. And we do it every other Thursday. So we'll have one today, we'll have one in 2 weeks, and so on. The concept is, first, the presenter will give a 15-minute talk, and then we have 10 minutes of Q&A, which will be moderated by Aline Lutz, who is the Senior Medical Director at SegMed, and by me. So all attendants, make sure to put your questions in the chat so that we can discuss them during the Q&A phase of this presentation. Today, I'm proud to announce that we have Elizabeth Litton amongst us. Elizabeth is partner at Fox Rothschild and has 23 years of experience in the industry, serving as national and regional counsel to hospital systems and healthcare facilities, to health plans and tech companies. She's been named as one of the leading healthcare attorneys in New Jersey by Chambers USA for each of the past 3 years. Elizabeth got her law degree from Rutgers Law School, and today she's going to talk about regulatory and ethical considerations for using de-identified patient data for AI. Elizabeth, the floor is yours.
Thank you so much, Martin. I have to say, sad to say that number of those digits were transposed. I've actually been practicing for 32 years to date myself a little bit, but I'll go ahead and begin the presentation. Thank you all for joining me. So, can you all see my screen?
Yes, we can see it.
Terrific. So, as Martin mentioned, I'm an attorney. I am a partner with Fox Rothschild in our Princeton, New Jersey office, and I also serve as the firm's Chief Privacy and HIPAA Compliance Officer. And I really wanted to focus on this issue today because there are a number of regulatory as well as ethical issues that arise when you consider using patient data, even de-identified data, for artificial intelligence or machine learning, algorithmic learning. So in the United States, I'm going to focus on the US for a few minutes. I think we have some good examples here in the hodgepodge and patchwork of regulations that apply can illustrate some of the issues that I wanted to discuss this morning. So in the United States, HIPAA, which stands for the Health Insurance Portability and Accessibility Act of 1996, to show how old this law is, but it still remains the most comprehensive regulatory scheme for health data in the United States. And it has been amended. There are regulations that have been adopted, and it has been amended. It was most recently amended through the HITECH Act in the early 2000s, and then the HITECH Act was again amended last January in a very minor way. But it has been around for a long time. There is still a lot of confusion about when HIPAA applies. So HIPAA does not apply to all health information, and this is an area of continued confusion for a lot of people, including health law attorneys in the United States. HIPAA only applies to covered entities, business associates, and their subcontractors. And those are very specifically defined terms under HIPAA. A covered entity is either a health plan, a healthcare provider that transmits health information electronically in connection with a standard transaction. That's a mouthful, but that's most healthcare providers, but not all, as well as a healthcare clearinghouse, which is an entity that converts data from standard to non-standard or vice versa, typically in the context of claims administration for healthcare claims, but not always. Now, business associates and subcontractors are vendors that provide services to covered entities that require access or use, disclosure, maintenance of protected health information. So that's the entire world of HIPAA. It only applies to these 3 types of entities. So it doesn't apply to all health information. It does not apply to all individually identifiable health information. And it does not apply to information that is disclosed in accordance with HIPAA properly to third parties outside, to a third party who is not a covered entity, business associate, or subcontractor. Now, the way in which the public is supposed to understand how their health information may be used or disclosed by a covered entity, business associate, or subcontractor is through the notice of privacy practices. So the notice of privacy practices is a notice that is required to contain certain elements and be provided to either a patient or a health plan member. And it will describe, ways in which the information will be used and disclosed. And there are a number of required elements in the regulations, but it is also supposed to include specific information unique to the covered entity and describing ways in which the health information may be used or disclosed. Now, HIPAA, interestingly, it also does not apply to data once it has been de-identified in accordance with HIPAA. To be de-identified, the data must delete 18 very specific identifiers. And there are two ways to do it. The first is it's called the safe harbor method, the removal of the 18 identifiers, plus the covered entity or the party doing the de-identification must have no actual knowledge of anybody's ability to re-identify the data. The second method is called the expert method. And under the regulations, this means that an expert using generally accepted statistical and scientific principles for rendering data unidentifiable will go through the process to do that and document how that is done. The limitation or the concern with de-identification is that it's a determination made at a moment in time. So it's a temporal determination. Information can also be disclosed and pursuant if you disclose a limited data set. A limited data set is similar to a de-identified data set, but it only includes the removal of 16 identifiers. There's no actual knowledge element to it. And the things that could be included in a limited data set that are not included in a de-identified data set are things like postal, street address, and dates related to the individual. So you could include dates of service or dates of birth. Whereas if you were to deal with the identified information, you could not even have a date of service. A date of service in and of itself would render that data protected health information, even if it didn't have a name or any other specific identifier. A limited data set, though, unlike the identified data, a limited data set requires a data use agreement between the data holder and the recipient. And that's significant because the data use agreement under the regulations has to prevent re-identification. We are missing that element in the de-identified definition. And oh, by the way, the identifiers pertain not just to the individual, the patient or member, but to their relatives, employers, and household members. There are other regulatory schemes in the United States that affect health information. I'm just going to walk through these really quickly just to mention. We have the Genetic Information Non-Discrimination Act, which deals with, obviously, your genetic information. And the idea there is you don't want your insurance carrier or anybody else to discriminate against you based on genetic factors. Human subjects research laws, this is the common rule, and this goes back many, many years, but it protects individuals who are participating in human subjects research. And there are limited, but there are privacy protections in that statutory scheme. What we refer to as Part 2, which is a specific, it's more stringent than HIPAA, but it's specific to substance use disorder treatment services, and it has more stringent requirements for the use and disclosure of data. The Federal Trade Commission in the US has a very broad statutory ability to regulate and bring actions against parties who engage in unfair and deceptive practices, which the misuse of health information data could fall under that category. In addition, there's a health breach notification rule for data that is not subject to HIPAA, but is maintained in a personal health record. So that would be something I might hold in an app, my own personal health record. An example of a personal health record that was in the news recently in the last couple of years is Flow Health, which was a widely used international app used by women to help determine their menstrual cycles for purposes of pregnancy, ovulation. And there was a major breach of privacy with the use of that involving that company, and the Federal Trade Commission has slapped the hands of the company. We also have an array of state data privacy laws, which pertain to many, all across the board, to individually identifiable data. There are some variations in the states that have these laws. We have about 5 right now in the US. And sometimes there's a carve out for HIPAA. So you could have health data that's not subject to HIPAA, that is still subject to state privacy law, but the HIPAA regulated data, the protected health information, would continue to be subject to HIPAA. Also, there could be no applicable law, which is why I wanted to discuss the ethical issues, because I think the legal system cannot possibly keep up with the pace of technology. And so the stopgap, in my mind, and I often go through this, if there's no clear legal answer, there's no clear legal regulatory scheme that applies to the use of data, I think it's good to think about the ethical issues. So I'm going to quickly touch upon those. Now, this is a quote I took from the Future of Privacy Forum, a DC group that was created to think about ethical uses of data. And here's a quote from that organization. Scientific research is often dependent on access to personal information, whether collected directly from individuals or collected for real-world use and then accessed for research. For research to be trusted, processing of personal information must be lawful, ethical, and subject to privacy and security protections. So obviously, we don't want to stand in the way of progress. We want our health data to be used in ways that will improve our individual health and the public health, and meet society's, meet goals for society. But we also want to make sure that we can trust the research, we can trust how the data is used. Here's some ethical considerations that I pulled from the forum. They identify several ethical concerns. Loss of opportunity. In the healthcare world, that would mean perhaps differential access to healthcare treatment or coverage. So if there are standards created for, when to provide immunizations or how to provide a certain treatment to a certain part of the population, we want to make sure that we're not inappropriately reducing access to life-saving or life-improving care based on problems with the data. There could be economic loss. People have to pay more or charge more for certain things. There could be just a generalized social detriment, such as reinforcements of stereotypes or confirmation bias. We see that in a lot of discussion right now about what is fake news. Do we gravitate toward what we already believe? And then another ethical consideration is the loss of liberty. And I added this in, this is my commentary on that. I think of loss of liberty as also sort of involving the loss of privacy, which is the ability to go about our business without feeling that we're being followed or watched, and that we're being placed in a position that we don't feel comfortable, in which we don't feel comfortable. So some other concerns that come up. So when we're looking at use of health data for artificial intelligence or machine learning, I think there are a few things to ask. What are the expectations of the individual at the time the data is collected? So I talked about the notice of privacy practices, but with the notice of anticipated uses and disclosures, we want to know, is the notice itself, is it accurate? Is it an appropriate mechanism for communicating with the individual? Does anybody read the notice of privacy practices? We have to look at evolving technology and evolving use cases. So there could be, recently we see a lot of use of socioeconomic data from health data for public health purposes, and that's great, but we need to be conscious of what we're doing and what the expectations were of the individuals at the time we collected the data. Did they know that we might be looking at how much money they make in connection with their diabetes? We also need to think about the ownership of the health data itself versus the ownership of a product derived or a tool derived from the product. Benefits versus harms is something else we should think about. So we want to think about the availability of the data in order to improve health, and accountability of the data in order to make sure that we have an ongoing conscientiousness about how the data is used in the evolving uses of the data. So we obviously want to support the use of data for societal benefits. We want to support a learning system for health where we're constantly improving and learning ways that we can improve our healthcare universe and improve the population health. But we also have to think about, well, can we re-identify individuals when we talk about de-identified data sets? As data sets are combined into larger data sets, can we identify individuals? Who's going to be using the data? Is the data leaking into the wrong hands, into the hands of marketers or others? And if we're using the data for automated decision making, I think it's always potential that there's always the potential that there could be illegal or unfair individual or societal harms. We also need to make sure we're checking for bias in decision making and unintended discrimination. Last, I wanted to point out a couple of potential remediations to these issues. So I alluded to these earlier, but I think some of the things that we can do either individually within a company to make sure we are not running up against ethical issues. And these are principles consistent with many of the regulatory schemes as well. So we want to regularly review the data methods that we've used to weed out historical bias. And we want to check to see, are we using proxies for protected classes? We want to regularly check the algorithmic design. Is it still functioning properly? We want to think about implementing fair information practice principles. Generally, this is a standard that's used across many organizations. I put here plus because I think, I think the principles need to evolve and be reevaluated. There is some negative publicity about the U.S. Department of Homeland Services using data potentially improperly. So we want to be conscientious of looking at FIPS and how we're using it. We can conduct a data protection impact assessment. So this is a concept that comes out of GDPR, the European Union's privacy standards, regulations, and that's something that I think we can do that in industry by industry. We want to also, with respect to the review of the algorithmic design, we want to see, are there triggers built in to alert us if we need to go in and look at a manual and manually review the AI. And think about setting up an ethics committee and bounce new projects and use cases off the ethics committee and make sure that there's nothing you're overlooking, unintended consequences with respect to the use of the health data in AI. So that's all I have for the moment. I'm happy to answer any questions you have.
Thank you, Elizabeth. It's great to hear from an expert all these relevant topics. Now we are opening for a Q&A session. So there's a first question from Jay. He's asking about safe harbor versus the expert method. So Jay thinks that the expert method is a bit vague. So how can we better define when a data set is properly de-identified by the expert method?
The expert method is vague and it's not relied upon. It's not used very often. I think in most cases, most instances, companies will rely on the safe harbor method. The expert method is used sometimes where there is a data element that must remain in the data set, such as date of service. I'll use that as an example. But perhaps the data pool is so broad and pulling from so many different resources that a statistical expert could determine that there's a 0.0001% chance of being able to figure out who that individual is based on just that data element being included. So it doesn't qualify for the safe harbor because you have a date of service or you have some other minor piece of information, but you are explaining why you consider it de-identified. So I think there's a place for it, but it's usually used in a very, it's not used very commonly.
Okay, thanks. So there's another question from Gunjan. He's asking, does HIPAA apply to re-identify data after a combination with another data set?
Excellent question. That's an excellent question. Unfortunately, and I say this from the perspective of, patient privacy perspective, unfortunately, no, not really. However, if that re-identified data then goes goes into the possession of somebody who's subject to HIPAA, arguably it becomes HIPAA protected health information once again. The other concern, though, is that if it's re-identified, very often the blame will fall with the covered entity. So if it's re-identified, and let's say I had cancer treatment at a large institution, and they de-identified my information to use it for some purpose, but the business associate, let's say it was Google or somebody else, and it inadvertently got combined with larger data set, even though it was properly de-identified in accordance with HIPAA, and the information is re-identified, and then suddenly it's out in the open, and someplace somebody discovers that I received this cancer treatment. I'm going to be really annoyed at the covered entity because they were the one I entrusted with the information. And so I think you could end up with a privacy claim under state law, common law. There's no private right of action under HIPAA, but we're increasingly seeing individuals who suffer as a result of a breach bring an action under state law or use HIPAA as the standard of care for issues that occur down the line, breaches.
Right. And on the top of that, I would ask, what are some examples where HIPAA does not apply that you said earlier? What are the transactions that are not under HIPAA?
So if I'm using a health app, so I mentioned Flow Health. Let's say I use a health app, or let's say I'm using, in the US, we may, Roe versus Wade may be overturned, and we may have a hodgepodge of state laws governing abortion rights. So in the context of women's health, whether I'm monitoring something on my own, or if I'm disclosing information to a provider that or if I'm going out to a nonprofit, for example, and I'm disclosing information to them, even though it's health information, it may identify me. If that nonprofit or that health app is not a business associate, a covered entity, business associate, or subcontractor under HIPAA, which, as I mentioned at the beginning, are very, very distinct, discrete terms, defined terms, then that health information is not protected by HIPAA. If I tell my coworker that I got a COVID vaccine, if I tell my employer that I need to be out for disability, all those types of communications are not subject to HIPAA. So those are just a few examples, but once again, health information is only subject to HIPAA when it's created, received, maintained, or transmitted by a covered entity, business associate, or subcontractor. So everything else that falls outside that world is not subject to HIPAA.
Got it. That totally makes sense, Elizabeth. We have more questions. One other question from Jay. What threshold should people use for the statistical risk for PHI? Is it like 1% or 0.0001%? Because it's generally very hard to guarantee that there's no, like, a 0% chance for PHI leak risk, right? So with the safe harbor method, what do you think?
The HHS has not, the regulatory entity that oversees HIPAA and is responsible for enforcing HIPAA, there's no guidance on what that number is. And I'm not a statistician, so I think it would be, the language in the regulation that I talked about in the slide is using, accepted statistical analyses. And so I think you'd have to look to your statistician world to see, well, what's the interval of confidence, or, what makes sense in in the statistician's world? Can I justify my opinion here? Yeah,
we work with this question a lot. Of course, it was just interesting to hear what you, as with a legal background, would say about this. Okay, one last question from Michelle. So these regulations, they differ per country a lot. You have GDPR in Europe, you have HIPAA in the US. Shouldn't there be an effort to make this more internationally, since especially in the AI model world, they're applied in different countries. It's not, like these regulations are focused on one country, but the models are not. There's a little bit of a discrepancy there. What do you think about that?
If we could get there, that would be wonderful. Maybe we could have the smartest people from every country come together and figure out something that makes sense. but then there's the political aspect of getting the countries to agree. So in the United States, at least, you know, there's discussion all the time about whether there should be a federal standard for privacy of individually identifiable data that's similar to GDPR. I don't know whether that'll be enacted. We have this tension in the US between the state's right and desire to regulate and come up with its own standards and impose more stringent standards versus the desire to have a simpler, uniform, more practical, workable, understandable framework across the country. So that's a tension that I see happening in the US. And so as far as eliminating that tension across countries, that would be quite a challenge, but it would be wonderful if we could get there.
Yeah, that totally makes sense. That's going to probably be impossible, but it's nice to that it would. I see there are more questions, but we are running out of time. So thanks everybody for attending, and especially Elizabeth, thank you for an amazing, very good presentation. Your contact information is on the screen, so for people who want to reach out to her, there's an email address and a phone number, so feel free to reach out to Elizabeth. So thanks again, Elizabeth. In 2 weeks, we will have Marina Cordari. She's the head of clinical evidence at Arteris, present at the next Bites of Innovation. So I hope to see you all in 2 weeks again. And thanks again, Elizabeth.
Thank you.